welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case. So, just yesterday, I did a video on the interlocutory appeal that the defense has filed in order, well, it's a motion to get this to have Judge Gull certify her orders in order for them to get an interlocutory appeal. And that's part of the problem is they need Judge Gull's approval in order to take it to the next step, which is the Supreme Court. So, not so sure if she's going to grant it. However, today we just received a filing from Nick McClelland, and of course, the DA, the prosecuting attorney, and he is, of course, objecting to this the defense's filing that we just went through. So let me shrink myself here. And let's get started. We're going to go through this pretty quickly. It's short. So this is the state's objection to certification of orders to allow for interlocutory appeal. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to certification of the court's orders dated August 28th, 2024 and September 4th, 2024. So the first set of orders is where Judge Gold ruled that all of Richard Allen's confessions that were made under duress are coming into trial. And also the September 4th orders are the motion in limine that she granted basically in full for the state and basically handicapping the defense from having a defense. The defense that they've been working on this entire time, it's now they can't use. And we went through all of that yesterday in their filing. So, in support of the objection, the state would ask the court to consider the following. One, that on August 28th, 2024, the court issued an order denying the defendant's motion to suppress statements filed April 11th, 2024. Two, that on September 3rd, 2024, the court issued an order granting the state's motion in limine in its entirety, filed April 29th. Number three, that the defense is now asking the court to certify those orders to allow for interlocutory appeal and delay the trial setting. Number four, that under Appellate Procedure Rule 14b-1, which outlines the grounds for an interlocutory appeal, it states that if the order involves a substantial question of law, the early determination of which will promote a more orderly disposition of the case, the court can certify that order for interlocutory appeal. Yeah, so I think that applies here. I think it does. And number five, that in both the August 28th and the September 3rd orders from the court, there is no question of law to be debated. The law concerning the motion to suppress and the motion in limine is well established and clear. The orders in no way involve a substantial question of law. Rather, the issues presented and decided, which are the basis of the orders, are questions of fact. So if you're saying that it's a fact that the judge is ruling, it's a fact that this odinous stuff isn't related, well, you just shot yourself in the foot, Nick McClelland, because the jury are the finders of fact, not Judge Gull. Questions of fact are appropriately determined at the trial level by the presiding judge applying controlling law to the evidence presented and accepted at the hearing on both issues. Yeah, but you can't take away, I mean, there has been so much evidence that the defense has put forth that any normal judge that isn't Gull would say, hey, there's something here. Maybe I should look at it. But not in Judge Gull's case. All right, so number six, that evidence as to both issues was presented at length by the defense, that the defense was not able to meet its burden on the suppression issue or in any of the issues outlined in the motion in limine concerning third-party motive, geofencing, or any other topic outlined in the motion. including the odinist ties, the ritualistic sacrifices, things like that. That the burden on the defense is well established by law in both of these areas. I would argue that in this 3-day hearing that the defense had, they have argued and I think successfully tied a connection to why they should use the geofencing and why they should use this third party stuff. But Judge Gull says no. Judge Gull is the finder of fact, and apparently any facts that the defense puts forth or any evidence that the defense puts forth, Judge Gull rules it's not a fact, therefore it's not coming in, even though the jury is the finder of fact. Number 7, that the defense has not shown that the orders from August 28th or September 3rd contain substantial question of law. 8, that an interlocutory appeal would delay the trial for a second time, that a delay of a long, complex trial so close to the start date is burdensome on the state and on the family of the victims, as well as financially burdensome on the county. Like Nick gives a crap about financially burdening the county. Number 9, that given the fact that the law is so well established in these areas, there is a high unlikelihood of a different outcome at the appeals level. Bull, absolute bull, because I think uh, uh, why am I having so much trouble with words today? Um, an objective panel of Supreme Court judges looking at this case found differently, found to look at this case differently than Judge Gall in some ways. Why they didn't kick her off, I don't know. But they did find that she had maybe overstepped her bounds. And I think she's doing so again. Not, I think, I know she is. Not, I think. She definitely, she's totally handicapped him and taken away his right to a fair trial. All right, so number 9, that given the fact that the law is so well established in these areas, there's a high unlikelihood a different outcome would happen at the appeals level. Sorry, I already read that. Number 10, therefore, the burden on the state, the families of the victims, and the county of continuing a long, complex trial so close to the start date is greatly outweighed by the limited chance of a different outcome in an interlocutory appeal. Um, just because he thinks that it's not, just because he thinks we're not going to get a different outcome doesn't mean diddly squat, in my opinion, because I don't trust Nick for a second. That the motion to certify the orders for interlocutory appeal should be denied, that this filing should be shown as a waiver of the 15 days permitted for any response as set forth in Appellate Procedure Rule 14B, and no additional response will be submitted. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests this court to deny the motion by the defendant to certify the orders for interlocutory appeal. Big surprise that he is objecting. Further, the state would ask the court to maintain the current trial dates and for all other relief just and proper in the premises. I don't know. Being that I am not a lawyer, I don't know what their next step is if Judge Gull denies this, but there's got to be something she can do. I mean, this is crazy. When have you ever heard of the state saying, let's not use geofencing data? It can't come in. That's their own tool. Like this whole thing, the motion in limine doesn't make sense. He has a right to say, hey, I didn't do it. And if I didn't do it, somebody else did. He has a right to say that. In this country, you have a right to do that. In some states, they're a little more strict in how you can bring that evidence in. But I don't think they even have a third party culprit rule in Indiana. I think. I'm not sure. But you still should be able to say, hey, who are the other suspects that weren't looked at in depth or were maybe looked at but covered for, perhaps. I don't know. That's something that the defense needs to be able to question the witnesses in order for them to have a fair trial. And to take that away, just it's gut wrenching. It really is for the defense. It's a total, like they said, they were totally transparent with what their arguments were going to be. And then at the last minute, Nick McClelland's like, hey, let's set a motion in limine to exclude all of the things that the defense has been saying for the last, I don't know how many months. It's pretty crappy and unethical, if you ask me. And there has to be some kind of recourse for this. So even if she doesn't sign this interlocutory appeal, or certify, whatever it's called, I sure hope that there is something else that they can do besides this, other than I have a feeling she's just going to flat out deny it, and this is going to be like the worst trial ever for a defendant who is most likely innocent. So think about that. I'm sure we'll probably hear something today. If I do, let me see. While I'm here, nope, I haven't, don't see anything from in my Delphi docs. I haven't seen an order come in because this just came in this morning. So I'm surprised it wasn't like right behind it going approved. Granted, whatever Nick wants, Nick gets. That seems to be how it goes around. Um, what what county are we in? Carroll County? Carroll County. Ay, ay, ay. Let me know what you guys think in the comments below, and I will keep you up to date as soon as I find out the orders from Judge Gull. So thanks for watching. I'll see you guys in the next one. Please hit the like button on your way out. Bye, guys.